Professor Richard Barnes of University of Lincoln, University of Tromsø, on the topic Judicial Dialogue and its role on systemic integration of international law. You have the floor.
Thank you very much for the introduction, Judge Kittasharsari. First, let me begin by saying a thank you to the Korean Society for International Law, the Ministry, and the International Tribunal for supporting this wonderful conference and for giving me the opportunity to speak to such a well-informed and engaged audience. I hope my talk will do this conference justice. So, as to the topic of my talk, I think it's fairly self-evident why I'm here to talk about the recent advisory opinions and the relationship between the two decisions and the way in which the judges interacted in terms of formulating their decisions. But perhaps it's maybe less clear why I'm here to talk about judicial dialogue, and I'm thinking particularly from the fact that I'm an academic, and sat in front of me are members of the tribunal, and beside me there's another member of the tribunal, and they're possibly better qualified to talk about judicial dialogue. So I humbly stand to be corrected if I get all of this wrong. But anyway, I think judicial dialogue is important. I mean, judges are people, and people talk all the time, and I'm sure it's important for judges to talk, perhaps about the weather, why they received an invitation to this conference. You know, is the boss making them to work too hard? But what I'm focusing on more particularly here is not just this general dialogue, but the specific dialogue that judges have in respect of their judicial function. So how do they speak to each other as judges? And then how can this contribute towards the more effective exercise of their judicial function? Or in other words, to better international jurisprudence. So in my presentation, I'd like to begin by spending a little bit of time about explaining about what judicial dialogue actually means and perhaps how it's put into practice. And I think the starting point for my talk here is that in the absence of what you might call formal institutional relationships between different courts and tribunals, then the kind of formal and informal dialogue between judges can assist with the integration of rules, institutions, and systems in varying degrees. Now, of course, I mean, we might say that this is just a function of law more generally, but I think when we talk about judicial dialogue, what it does is it puts to the fore, I think, the critical role that judges have in enabling that process to take place. But obviously, the counterpoint there is that judges are individuals, they have opinions and they have values, and the question might ask then, how do those different values and approaches inform the way in which they use the different tools for systemic integration? Having said that, what I would then like to do is to see how this process of judicial dialogue has been applied in the two recent advisory opinions there, and to illustrate perhaps how different accounts of judicial dialogue have come to the fore, and how we can perhaps extract some evidence about the nature of judicial dialogue. And I think for me, the kind of challenge here is that when we look at the jurisprudence of international courts and tribunals, we tend to kind of pick through things in meticulous detail and understand the way in which judges cross-refer to each other's judgments. But perhaps what's more difficult in practice is to identify some of the kind of wider reasons for that. So hopefully my talk will contribute towards a broader understanding of some of those reasons. Okay, so what do I mean by judicial dialogue? We have a couple of definitions on the slide here. The first of these is from Samuel and Bajuelos, and they talk about judicial dialogue as simply being communication between judicial authorities. So it's a very open concept and definition of judicial dialogue. And perhaps a more specific definition of dialogue is provided by Anne Peters, and she talks about it in terms of courts' mutual attentiveness to each other's case law and cross-citations here. And I think this is important because what it does is it draws attention here to the actual practice of judicial dialogue. As lawyers, we're very much focused on the text of judgments, and so we need to find evidence of how this takes place in practice. And whilst there may be other kind of reasons why judges rely upon or make use of things, what we have to rely upon in terms of our understanding of this is what's actually written down in practice. As a kind of an illustration of this, I mean, yesterday when Judge Haidar gave his talk, there was then when Sir Michael Woods gave his talk, Judge Haidar came back and responded to perhaps the sort of criticism of the jurisdictional elements of the course's advisory opinion. And the point that Judge Haidar was making here was just to seek to clarify perhaps the rationale for the tribunal's decision there, and to emphasize the fact that whilst there perhaps has been a historically uncertain basis for the tribunal's advisory jurisdiction, there is also the idea here that the court has retained a high degree of discretion in terms of how it might apply that. And that's not something that's kind of written down here, but perhaps informs the ways in which we understand how judicial dialogue can happen in practice. So, when then is judicial dialogue relevant? Well, perhaps 4 different situations when I think it becomes very prominent. So the first of these here is when courts address the same subject matter. And I guess the basic point here is that when courts address similar subject matter, whether it's climate change or maritime delimitation, there is value in ensuring that their decisions are consistent, they're not leading to conflicting jurisprudence. And so it's very much a practice which occurs in that situation. The second situation is where courts and tribunals address cross-cutting legal issues, for example, the interpretation of treaties, state responsibility. Again, it's important when these cross-cutting issues of international law are addressed in a coherent and systematic manner. The third situation where it becomes relevant is in what you might call highly complex disputes. Very few disputes under international law are located within specific issues which can be identified and dealt with separately. Often what happens in one area of law influences another area. So again, it demands a degree of consistency between different areas of substantive law when they're applied in complex disputes. And then lastly, it may arise in situations where there are new legal issues, for example, climate change. And here there may be a formal lack of authorities, for example, within the jurisprudence of ICLS or even the ICJ. And so it has to reach out into other areas of judicial practice to try and find some guidance for how it may resolve a dispute. Now, in terms of the factors shaping judicial dialogue more generally, I've put on this slide here a quote from the ICJ and the Climate Advisory Opinion. And I think what this does nicely here is that it shows perhaps some of the tensions which are at stake when the tribunal or courts have to deal with this. So the International Court there stressed that in terms of its judicial function, what it's called upon here is to try and resolve the dispute in front of it. So in most cases, this is the kind of primary function of an international court or tribunal. But then in the next, or in the same paragraph, the court then goes on to say that what it hopes is that its judgment will then perhaps have some degree of influence in helping states or the audience, the international community, in addressing some of the severe consequences of climate change here. So this kind of begs the question here as to whether or not judicial dialogue, cross-referencing, is something which is very specific to the case. Is it something which is shaped just purely by the factors of an individual case? Or is it something where judges have in mind this idea that they have to be aware of what the kind of wider consequences of the decision are for various constituents? Anyway, in terms of judicial dialogue, it can take a number of different formats. So we can have what we call the difference here between horizontal and vertical dialogue. So horizontal judicial dialogue is effectively exchanges of ideas and citations between courts which have equal standing. So for example, ICLS and the International Court of Justice, there is no formal hierarchy between them. It can also take place vertically, for example, between lower courts and higher courts, but also between, for example, international courts and domestic courts. So really what we're concerned with here in my talk is horizontal judicial dialogue. But it can also be informal and formal. So, for example, there can be the exchanges which judges have outside of chambers, within conferences, at training events, even informally. But it can also be the kind of formal dialogue which is recognized and recorded within the jurisprudence of tribunals. So I'm very much concerned here with the kind of horizontal and formal dialogue between judges. Now, there are a number of different theories of judicial dialogue which have been advanced in the literature. So just to run through some of these quickly. We can have deliberative theory, and the idea here is that dialogue is kind of a function of what judges do, and by engaging with each other, they can use ideas or legal reasoning to help improve not just the quality of their judgments, but also to ensure that there's a kind of wider participation in the formation of international jurisprudence. A second theory of judicial dialogue is what's been termed constitutional pluralism. And this is the idea here that in a kind of an international legal system where we don't have a formal hierarchy, then there has to be a mechanism for managing the formal relationships between different courts and tribunals. And so the exchange of ideas and jurisprudence between different tribunals can help kind of manage the relationships between these institutions. There's the idea of network theory, the idea here that judges are part of a network of international courts and tribunals. And so what they do as part of this network is, again, to kind of share and exchange ideas as members of this decentralized network. The fourth theory here is what we call kind of normative integration theory. And I think this is perhaps the one which is perhaps most strongly or commonly associated with judicial dialogue here. The idea that in order to maintain the systemic coherence of international law, judges have a responsibility to ensure that when they exercise their judicial function, they take into account the consequences of their decision for other courts and tribunals, but they also rely upon the jurisprudence of other courts and tribunals to help ensure that there is a degree of harmonized application of the law. A fifth theory is the idea of strategic interaction. The idea is that courts can somehow enhance, for example, the value of their judgments, the legitimacy of their judgments, by relying upon the jurisprudence of other courts and tribunals. But also, in a perhaps more cynical way, some have argued here that by asserting their degree of control or, for example, approval of the jurisprudence of another court or tribunal, it allows them to kind of be seen to be in control of a particular matter. And so this kind of reflects the idea there may be a degree of competition between courts and tribunals to show their authoritativeness. And then lastly is the idea of judges being part of an epistemic community of practitioners here. They share common values, they reason in the same way, and so the idea of judicial dialogue is it's a manifestation of their membership of this judicial community. So each of these kind of places different emphasis on the way in which judicial dialogue is applied in practice. Okay, so the reason why this is important, I think, in practice here, as I emphasized at the start of my talk, is that in practice, we don't have a formalized system of precedent under general international law. Article 59 of the ICJ statute and 296 of UNCLOS here kind of restate this kind of basic principle of international law. And so because there is no formal system of precedents, the idea then is that we have to kind of understand the way in which different decisions of different courts and tribunals can be relied upon and interface. A second element which kind of controls and constrains judicial dialogue is the issue of applicable law. So whilst judges perhaps are free to rely upon and make use of jurisprudence from different courts and tribunals, they can only do so within certain bounds. And so, for example, under the Law of the Sea Convention, the jurisdiction of a court seized of a dispute under Part 15 is limited to dealing with matters which concern the interpretation and the application of the Convention. And whilst there is a provision in terms of the applicable law, it's generally agreed that, for example, the applicable law that the tribunal applies to a dispute cannot expand its jurisdiction. Now, there are some kind of cases which perhaps play with the boundaries of that. So, for example, the case of the MV Saiga, they've taken a much more aggressive approach to including, for example, norms on the use of force as part of the law of the sea. But in other cases like Arctic Sunrise, for example, international human rights law has been something which has fallen outside the scope of the applicable law. So there are these kind of structural constraints on what can be part of judicial dialogue. In terms of practice, it's quite clearly evident that international courts and tribunals do rely upon each other's jurisprudence. So, for example, the Amadou Sado Diallo case was the first time in which the International Court of Justice had relied upon jurisprudence of ICLS, and there it relied upon it there to deal with a question of quantum of damages and the creation of interest rates. And so because the International Court hadn't dealt with this particular matter, it felt it was appropriate to rely upon ICLS, which had dealt with this. And again, there's quite a regular dialogue between judges in maritime delimitation cases. And for the sake of time, perhaps this is one for questions here. One of the things I'd flag up here, though, is that this is perhaps a bad example of judicial dialogue because the kind of consistency of jurisprudence between the two tribunals is not entirely, satisfactory, shall we say. There are kind of wider tools which exist, which judges can make use of in terms of judicial dialogue. And I suppose the question I wanted to sort of pose here is that given that we have these tools, for example, conflicts clauses in treaties, we have the ability under Article 38 of the ICJ statute to rely upon the decisions of other courts and tribunals, we have the mechanisms on systemic treaty interpretation under the Vienna Convention. Do we need a kind of concept of judicial dialogue to actually, make sense of this or not? But I think one of the things I wanted to stress here, though, is that even if we have these tools available to judges, they still have to be able to exercise a degree of control over how these tools are used. And so it's for the judges themselves, as McLaughlin points out, to decide what rules are relevant and what importance to attach them. And for me, this is the thing which I think is quite difficult to ascertain from a kind of simple reading of international jurisprudence. So, bringing then, sort of having outlined how judicial dialogue may work in theory and given some examples of where it applies in practice and some of the constraints on this, the question is then, well, how did this operate within the recent advisory opinions? Well, I guess the kind of starting point here is that these are two very good cases to use in terms of illustrating how judicial dialogue operates. And this is primarily because the cases involve novel issues, because there are questions which were posed of the courts concerning, for example, what are states' obligations in various respects to deal with the issue of climate change, and which are very complex issues. So it provides a very good opportunity to explore how judges engage with each other in terms of framing the international legal rules on addressing climate change. Now, there are some kind of general observations which were made by the International Court of Justice in terms of how it would address these issues. And obviously, the court itself was aware that previously ICLS had issued its own judgments. And I guess the question here was to clarify the situation where you've got two tribunals dealing with similar issues but with slightly different kind of framed questions. And I guess the point I wanted to emphasize here is the kind of idea that although there is no formal hierarchy between the two courts and tribunals, the judges themselves do manifest this sort of sensitivity to each other's judgments. So as the court stated here, it should ascribe great weight to the interpretation adopted by the tribunal in order to achieve the necessary clarity and essential consistency of international law as well as legal security. Now, this was actually drawn, I think, from the earlier case of Amadou Diallo. And that case concerned, obviously, the application of international human rights law, and there the International Court of Justice had sort of spent some time explaining that whilst, again, not formally bound by the kind of views of the Human Rights Committee as regards the meaning of the International Covenant on Civil and Political Rights, it had to give weight to its opinions, as it were, as being the kind of responsible agency for doing that. And this was something which it reiterated in respect of ICLS as the guardian of the convention. The second thing which I think arose as a kind of general matter here is that the court had to deal with the issue of the relationship between systemic interpretation and the lex specialis rule. So a number of states had raised this question in the proceedings as to whether or not it would be appropriate for the court to kind of speak to the nature of states' obligations more generally in terms of preventing or dealing with the issues arising from climate change, when we had a very specific set of legal regimes under the UNFCCC and the Paris Agreement which set out states' obligations. And so a number of states took the position that, well, given that there is a special regime of climate law, that it is unnecessary for the court to actually speak to the kind of general obligations which states have. And I think there had been a kind of sense here that if we have this idea of a special law on climate, then we don't need to. It takes priority over the kind of more general obligations which exist under customary international law. But interestingly, the court kind of rejected that point here and took the kind of view that, well, actually, in light of kind of fragmentation, we have a number of tools available, including lex specialis. And the idea is that what the preference for the court is to try and adopt a more integrated approach here. So try to kind of reconcile this idea of lex specialis with the idea of systemic integration. So just then moving on to the kind of final, penultimate slide that I have here. What this sort of sets out here is a series of kind of select issues which were addressed by both courts and identifying the kind of relevant parts of the judgment. And I think what I wanted to do here was just to kind of simply illustrate how both tribunals, or the court and the tribunal, dealt with both of these sets of issues. And it's to respond to the idea of a kind of criticism of judicial dialogue, because some have made the kind of observation here that judicial dialogue ought to be a kind of two-way exchange, but when courts are engaged in cross-referencing and citation, it tends to be a one-way practice. So although, for example, the ICJ relied upon the judgment of ICLS in a number of different ways, actually what you tend to find is that ICLS itself, in terms of forming its opinions and giving its advisory opinion, had also relied upon the earlier jurisprudence of the International Court of Justice. So what this suggests here is that judicial dialogue is not something which happens at a kind of single point in time, but it's something which I guess judges do over time and kind of space here. The idea is that judges will look back but also look forward and think about how they're using the jurisprudence from different tribunals in order to kind of build a body of law over a period of time. So law being a kind of iterative process, judicial dialogue is the way in which that process takes place. Now, it's not always done consistently, and I think, as the slide kind of illustrates, there are, for example, areas where, for example, due diligence showed a kind of progression from pulp mills to the idea of a strict or stringent due diligence in the most recent climate change advisory opinion. But there are kind of other examples of where this couldn't take place. So, for example, in terms of human rights obligations, whilst the International Court was able to deal with these, the International Tribunal for the Law of the Sea took a very kind of reserved position on this one. And so I guess it shows that, for example, because human rights law is not an applicable law for the tribunal, it then has to kind of try and... It means that there are kind of limitations to the extent which judicial dialogue can actually take place. So just to round off with some very sort of brief comment, sort of conclusions here. Judicial dialogue and systemic interpretation, I think, play a very important role in terms of kind of helping hold together a very under-constitutionalized system. So judges kind of perform that kind of function of advocating the rule of law in kind of holding together the international legal system. Of the kind of theories which I put forward for judicial dialogue, it seems to be the kind of normative integration theory which best accounts for how things operate in practice. I think it's very important in a third way, and this is the idea of addressing normative deficits. International law abhors a vacuum, and so dialogue and the drawing upon jurisprudence across tribunals can help kind of fill those gaps in terms of law making. The penultimate point here is that judicial dialogue is very much the kind of practice or culture behind how systemic integration actually operates. And then finally, the point is that through this kind of practice, I think the International Court and the International Tribunal for the Law of the Sea have taken great steps forward in terms of ensuring the system functions effectively. But when we look at the jurisprudence, it's not always clear sometimes what the rationales for that are. Anyway, sorry for going over, but thank you for your time and attention.